The Honorables, the presiding Chief Judge and Judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save the state and this honorable court.
Good morning and welcome everyone to the virtual Court of Appeals. Your panel this morning was, I'm Chief Judge Donna Stroud. The other judges on our panel today are Judge Lucy Inman and Judge Fred Gore. And we have one case for argument today, and it looks like our attorneys are all ready to proceed. So we will get started in just a moment. Also, just wanted to let you know that our timer that you should be able to see on the screen is automatically set for 5 minutes of rebuttal. If you want to change that, let us know, and I believe Mr. Soar is probably the one controlling that today. But whoever is doing that can fix it if you want to change it. If 5 is okay, then that is how it is set by default. So, is that all right? Okay, that looked like an okay. All right, then we will go ahead and proceed with the appellant.
May it please the court, I'm Clark Fisher of the 23rd District Bar representing the appellant Yadkin County, and I would like to make sure that my 5 minutes of rebuttal is reserved. That is just fine. While I do wish we'd had the opportunity to come in person, appreciate the opportunity to be here in this 21st century proceeding. The primary issue before the court today is whether the Property Tax Commission, affording Yadkin County the presumption of correctness required by all the controlling precedents, made proper findings to support its conclusion that the county's schedule of values applied an illegal method of valuation, resulting in the Unify T5 plant, the facility we're concerned with, being assessed at an artificially high level. The county position is that the commission's findings ignored some substantial evidence which showed that the county valuation was arrived at properly, and that the failure of the commission to make specific findings regarding significant aspects of the evidence, which I'll go through in a moment, require that its decision be reversed. What I'd like to do over the next few minutes is to go through some of the evidence for which either the commission made no findings or made findings that only reiterated portions of the testimony. The first area of concern is the failure of the commission to consider higher valuations asserted by Unify in its initial appeal filings. When the company filed with the Board of Equalization and Review, the company asserted that the plant had a value of $24,800. Of course, it had been initially assessed by Yadkin County at approximately $29 million. In its notice of appeal to the Property Tax Commission, Unify asserted that the value was $19.9 million, which is $3 million, of course, more than the value ultimately claimed at the hearing before the commission, and for which the commission ultimately ruled. Now, it's our position that these widely differing values asserted at different points throughout the proceeding raise issues of value separate and apart from the appraisal evidence that the company relied upon before the commission. And in order for the commission to reach the reasoned conclusion that the law requires, the commission needed to address these differing values and reconcile them one way or another. If you look through the commission's decisions, nowhere in the findings of fact is this issue addressed at all. Now, in kind of a reverse method, we contend, and we noted it in our brief, that the decision of this court in the Lowe's matter is pertinent. Now, that was a Forsyth County appeal in which the county assessed a Lowe's facility at a certain value. In my recollection, it was at around $14 million.
Mr. Clark, Mr. Fisher, I'm sorry, excuse me, Mr. Fisher.
I get that all the time.
I'm sorry, Mr. Fisher. Before we get into your discussion of the Lowe's case, I just want to make sure I'm understanding your challenge to the commission not mentioning that 19 point something million dollar figure that Unify
identified in its appeal. Would you agree that that figure is substantially less than what the county assessed the property
Oh,
to be?
it is certainly less, though it is not nearly as much less as the 24,800,000 that was also raised but not addressed in its initial appeal to the Board of Equalization and Review. So I think both of these higher figures than the amount presented by the appraiser, lower than Yadkin County, but significantly higher than the appraiser, are factors that the Property Tax Commission should have addressed and considered one way or another.
And do you think that the fact that they're not mentioned in the findings of fact reflects that the commission didn't consider them, or reflects that the commission didn't find it necessary to include them? And is that a distinction with any difference?
Well, Judge, obviously, I think that would be speculative. We can only rely on the decision and the findings that we have in writing in front of us. The commission is, of course, required to articulate in writing the basis of its decision, and part of that requirement is for the commission to resolve and consider all pertinent areas of evidence. So, sure, I suppose maybe they rejected it, but maybe they just didn't consider it. And when you have a silent decision, there's no way to know it all, and therefore I would contend that the decision is at a minimum incomplete, if that answers the court's question.
Thank you.
And again, what I was going to refer to with the Lowe's case, so there we had the county alleging initially about a $14 million value, then the appeal goes up, and at that point get a new appraisal, kind of like the company did in this case, just reversed, which came in with a higher value, somewhere 16 million or so, I believe. In that case, this court held that the difference between these two positions asserted by the county at different times called the initial valuation into question, and also had the county reap the loss in the case of losing the presumption of correctness. So in this case, we would contend Unify's filings, both the 24-8 to the Board of Equalization and Review, the 19-9 on appeal to the Property Tax Commission, both of which are between the 27 million ultimately determined by the county and the 16 million ultimately found by the commission. You have to consider these differences. When the county alleges two different values, didn't occur in a vacuum. The initial 24-8 was based with the assistance of a consulting company, the company hired out of Georgia. And I think it logical that Unify is presumably more familiar than anybody with basically the nature and quality of their facilities. Certainly, Unify is the willing buyer part of that willing buyer, willing seller calculation that the fair market value determination is ultimately based on. We would contend they probably didn't just pull those numbers out of the air. I'm certain that wasn't done. And so when you have these widely varying within this $11 million range figure, we contend that the commission had to make some finding about that. The absence of such a finding, we contend, is a significant deficiency. Let's put it in another setting. Let's suppose you had a homeowner who listed their property for sale at $250,000. Then there's a house fire. And then they claim $500,000 based upon a subsequent appraisal. You'd think that in that situation, the attorney for the homeowner's insurance company would consider that a significant factor. Here, the company alleges 16 million in front of the commission, but they've previously alleged almost $8 million more. Same rationale applies, and we contend that the failure of the commission to address that issue leads to the conclusion that those findings were insufficient. There needed to be some resolution. Certainly, the commission could have said, we don't assign any weight to it. In their brief, the company says well, that's really of no weight. But we don't know what the commission did or might have done, or whether it did anything, because the record in its decision is entirely silent as to that factor.
If I can just follow up on that again, and you did answer my question, but just, do we have any guidance from authority, not even in tax cases, but, in other cases, where the trier of fact makes findings of fact, and the appellant says, you left out some important facts that you didn't find, you omitted them. Is there authority that says the fact that it's not addressed in the findings means that the trier of fact erred? In other words, I am familiar with authority in various different contexts of civil and administrative law, in which there's almost a presumption that there is a presumption that the trier of fact considered all of the competent evidence before it. And unless you have a trial judge, or in this case, a property tax commission, saying, I'm not even considering that the presumption is that all the evidence was considered and weighed. Is there authority that goes the other way that I'm not aware of?
Judge, I cannot cite you to any specific authority to answer your question, but we have to look, I think, at what the ultimate role in the Property Tax Commission's review of cases is, and that is to consider all the pertinent evidence and to make a reasoned decision based upon findings of fact and legal conclusion to support it. And it seems to me a very basic factor that when there is not some tangential evidence, but significant evidence that factors nowhere in its written decision, that's something that this court can consider. I mean, let's suppose that they didn't put anything in their findings of fact about Mr. Ferris's testimony, the industrial broker. Well, he was pretty darn important in the case, and I don't see how you could have said, if that had been ignored, that the findings of fact would have been sufficient to support its conclusion. Same principle we would contend applies to ignoring these two significantly higher values asserted by the very party who is appealing the case and asserting a different value. And again, if you look at Lowe's, the logic works. That would be our position. Does that answer the court's question? It's the best I can.
Yes, it does.
Okay, thank you, ma'am. Moving on, we do find and do argue that kind of on the same vein, that there should have been something other than a recitation of testimony regarding the effect of international competition in the global markets on the valuation of the Unify plant. In this case, the company offered the testimony, I believe, of a Mr. I may not be pronouncing this correct, Mr. Mangaldus, who was a vice president dealing with various international and strategic aspects of business operations. And he basically said this plant is not going to be around much longer, that the foreign competition is just killing it. And if you look at the appraisal report and you consider Mr. Ferris's testimony, the decline in domestic textile production was one of the things that was considered. But if you read the finding of fact, it merely states that Mr. Mangaldus testified about that. And while certainly in some cases, as appellee correctly notes, just because you recite testimony, that can be fine if you integrate that into a findings of fact later. But that was not done in this case. And that segues directly into my next argument that, once again, the commission failed to note that there was countervailing evidence on this point. There was uncontradicted evidence from the company's own press release that rather than this being a dying plant, basically not worth much of anything, that they were expanding their operations to focus on environmental sustainability. The press release, Unify celebrates expansion of the Reprieve Recycling Center, which was a portion of the facility at issue. This was admitted by Mr. Mangaldis, and if you look at it, and that's in our exhibits, I believe at page 169, they go into great detail about how wonderful this expanded facility is, and that's significantly at odds with the picture painted by Mr. Mangaldis. But once again, that wasn't mentioned. This was a plant that was running 3 shifts a day, 24 hours a day, and that paints a totally different picture than that offered by Mr. Mangaldis. So when the findings of fact related to the economic issues surrounding it are only in a recitation of testimony, which this court has repeatedly condemned, and there is no ultimate finding resolving that issue one way or another later, we would contend that is a significant deficiency, particularly when the county offered that USA Today article going into significant detail. That was a 2014 article about the textile industry coming back to life, particularly in the South, painting a totally different picture than that offered by Mr. Mangaldis and the company's other witnesses. So a recitation of testimony without integration into a specific finding is, I think, a significant problem with the case. But what I really think might be the most significant issue for the court to consider is what we would contend are inherent problems with the various comparable sales relied upon by Unify and accepted by the Commission in its value determination. The Commission specifically concluded that the comps offered by Unify through Mr. Smith, its appraiser, were the best evidence of value. Now, even he had to admit that a number of his comps were, I guess, what we would call dark plants, abandoned facilities. In one instance, one of the plants had been abandoned for 8 years, even though Mr. Smith testified he was unaware of that fact. There were also major differences in the size of the plants that were used for comps, which were either somewhere between 316,000 and 477,000 square feet, less than half the size of the T5 plant, with the 6 being over 3 million square feet, well over twice the size. So our position is it was incumbent on the Commission to carefully examine these comparable sales and to articulate a reasoned determination about how they factor into the ruling. And they certainly have the discretion to, just like any finder of fact, to accept some, all, or none of the evidence before the court, but they have to make a finding to resolve it. But the resolution of that, and there was conflicting evidence from Mr. McCarthy distinguishing these various comparables, is found at findings of fact. Let me get that. Number 15. What the Commission said was that the county has raised potential issues regarding the property sales relied upon by the appellant in developing its sales comparison approach. But we nonetheless find the appellant sales comparison analysis to be more comprehensive than the county's. While there may or may not be issues with the choice of sales offered as comparable by the appellant, we determine the appellant's comparable sales are the best evidence. I'm not sure I have ever seen a finding like that in any context, be it administrative or other forms of court orders.
Mr. Fisher.
Yes, ma'am.
If I could ask, so the finding, are you arguing that the Commission has to basically go through the opposing evidence and explain exactly why it took with the other? I mean, this finding says, you know, we had these comparables. We determined that these are best. I mean, how much more detail, I mean, and are there any cases saying that they have to go into detail about the evidence instead of making an ultimate finding about what they determined to be the best evidence?
Well, Your Honor, again, they have to reasonably discuss the evidence, but I would submit they cannot just say there might be an issue with these comps. I mean, which is it? Might it or might it not be? But when they identify a potential issue right there, and clearly there was a significant issue just from the differing evidence that was presented, then I think they need a sentence or two about why, in light of these potential issues, that they made the determination they did about the company comps being the best ones. Again, particularly when there was no doubt a number of them were in fact abandoned properties, in some cases abandoned for many years. So that being the case, I don't think it is sufficient to say, well, there might be a problem, but we're going to go this way. I think a proper reason finding the fact has it at least somewhat more than that. Yes, ma'am.
Mr. Fisher, and I don't know if it can be bifurcated in this way, but what I've been understanding all of your arguments to be about the deficiency in the tax commission's findings of fact regarding the value of the property. Is that a separate question from whether or not the presumption of accuracy of the county's value has been rebutted? And the reason that I ask that question is looking at what the statutory standards for appraisal and assessment are, and then reading the testimony of Mr. McCarthy. The appellee is arguing that the appellant's various valuation approaches, including comparable sales, while there may have been some, and again, may or may not, whatever, let's assume that there were some problems identified with it. Let's assume that it's not perfect. That the commission said, that's the best we have here, because the county didn't do a sales analysis at all, because we find deficiencies in the cost analysis that the county did. In other words, so is rebutting the presumption and then setting the value, are those two separate issues, or are they intertwined and impossible to divide?
Well, I think they are certainly integral issues, Your Honor. And, you know, when I have made the argument based upon deficiencies of finding, that has to be considered within the whole umbrella of the presumption of correctness. The presumption of correctness, we would contend, cannot be rebutted absent reasoned and specific findings based upon the evidence presented to the commission. And yet, particularly as to this issue on the comps. No question, the commission had it within its authority, its discretion, to accept or reject any of them from either party. But if you're going to say there might be issues, again, I've never seen a finding of fact that says something might or might not be before, then you have to articulate a rationale for resolving that issue. That would be the argument I would make, Your Honor. But again, I certainly think all the findings, all our arguments as to the findings have to be considered in light of whether or not they are sufficient to rebut the presumption of correctness. Likewise, whether they're sufficient under the ultimate whole record test, the court has to consider to support the commission's decision in this case.
Mr. Fisher, for the finding that there might be issues about the valuation or the comps, wasn't that basically the commission recognizing the fact that there was evidence, there's conflicting evidence about it, that there was argument that these comparables are not good or whatever, and just acknowledging the fact that sure you could raise questions about it, but we have decided that these are the best, that this is the best approach. So I'm not sure why you're reading the fact that there might be issues about it as requiring additional findings.
Given that the comparables were such an important part of the case for both sides, no question. While the county's statement of values was not based upon a sales comparison analysis, Mr. McCarthy testified that it was a blended approach, and certainly Mr. McCarthy offered his own comparables to, as I think he said, I think prop up or buttress the schedule of values. But the commission has to resolve conflicting evidence. Fine, they did resolve conflicting evidence, but you don't do that, I would contend, in a proper manner, in a logical manner, by merely stating there might or might not be issues and then moving on. I would contend that in and of itself is an insufficient finding, Your Honor. That would be our position.
Mr. Fisher, on that,
Yes, Your Honor.
when you look at findings of fact 16, does that not resolve the fact that they've acknowledged there could be some differences, but then they do resolve the differences by saying the sales comparison approach relied might not be as appropriate than the cost appropriate in 16? Does that not resolve your issue by the commission?
Judge, I don't think it necessarily does, because well, I'm not sure. I think the cost approach is really what the schedule of values was based on. Mr. McCarthy testified it was a blended approach based upon a number of various economic factors. But again, I don't think you can say 16 resolves 15 without resolving that whether or not there's an issue. The commission finds we accept the company's comps, makes more sense to us, that's fine. That's not what it says. Might or might not, I think, is not the way we want our administrative bodies or courts to be doing findings of fact, and I think it certainly complicates review by this court. So unless there are further questions, I can't see the clock, so I'm not sure what my time is. It looks like it's getting close.
4.5, so, okay. You can't see it? Okay.
I see everything else, but we are doing great. This is
Okay, well,
much better than some.
I'm glad you told me that, because I know I've had some attorneys mention the fact that they've had difficulty keeping up with the time, and I'm not sure that would be a technical question for the IT people, but yeah, we need to make sure you can see that anyway. But you're at 4, and I'll give you benefit of a minute or two there for the technical difficulty of you not being able to see it. So,
Then I would reserve the balance of my time, and my thanks to all of you this morning.
okay, thank you.
And you really were close, within 30 seconds.
Yeah, it was 4.5. Yeah, so, but like I said, I'll give you the benefit of that, because
Thank you.
you should be able to see. I can see it, and I'm not sure, like I said, the technical details of that. But I have heard that complaint before, and that's something we need to figure out.
Well, it was on my screen before the argument started, and then it went away.
Okay. Well, we'll find out about that. So
Thanks,
for
ma'am.
letting me know. Okay. And now we are with the appellee.
May it please the court. May it please the court. Good morning. I am Collier Marsh with Parker Poe. I'm sorry, we're having just one minor technical difficulty. It looks like our screen is frozen.
That's okay. I started with the technical difficulties today, so you get to have some.
I'm going to move my laptop here. I apologize. May it please the court. I am Collier Marsh with Parker Poe. With me is Charles Renow, and we represent taxpayer appellee Unify Manufacturing, which we will refer to as Unify. Your Honors, the Property Tax Commission's November 21st, 2019 decision should be affirmed. The Property Tax Commission correctly found that the assessor used an illegal method to appraise Unify's T5 plant, and that the assessment substantially exceeded the true value of T5. The assessment relied entirely on an improper cost approach, an appraisal method that has been ruled unreliable and repeatedly rejected by this court. Making things worse, the assessor's cost approach failed to account for significant obsolescence of the T5 plant and failed to consider the true value standard by ignoring the market for the T5 property. Unify, on the other hand, presented testimony and reports from 3 different expert witnesses, as well as testimony from the county's own consultant, to rebut the presumption of correctness in this matter. Unify's expert appraiser was the only licensed and MAI designated appraiser to testify in this matter, and his opinion of value directly supported the commission's final decision. The Property Tax Commission, most importantly, correctly applied the burden shifting framework and correctly documented how it applied the burden shifting framework in its final order to reach its decision, and correctly then concluded that the true value of T5 as of January 1st, 2017 was $16,060,000. I'd like to turn back for a moment and set the stage for the property that we're talking about, as well as the history leading up to this final hearing. Again, this appeal relates to the January 1st, 2017 assessment, Unify's T5 plan. Now, T5 is an approximately 1.3 million square foot manufacturing plant used for the spinning and extruding of synthetic yarn. T5 is one of the last of its kind in North Carolina, and indeed one of the last of its kind in the United States. A large portion of T5 is a tower, a 6-story tower called F1 that's used for extruding the product produced at T5. F1, the best way to describe it, is a shell built around Unify's manufacturing equipment. So it has large holes in the floor for the equipment to pass through from the ground to the top. It has irregular heights based on what's located on a given floor. So those heights range from 9 feet to 20 feet in height. Again, this is just a shell built around manufacturing equipment. For the 2017 revaluation, T5 was assessed by the county's consultant, Ron McCarthy. And Mr. McCarthy used the cost approach as he testified at the hearing to value T5. His initial valuation was $29,033,042. Unify then appealed McCarthy's assessment to the Yadkin County Board of Equalization and Review. And the board agreed that McCarthy had overassessed T5 and had misclassified the property. So the county's Board of Equalization and Review reduced the value to $27,450,000 $27,450,242. Unify then appealed that decision to the Property Tax Commission, where it produced competent material and substantial evidence that the true value of T5 was $16,060,000, or more than $11 million below the county's assessment. On October 1st, 2019, the commission held its hearing on Unify's appeal and correctly ruled in Unify's favor. The Property Tax Commission correctly applied the burden shifting framework in this matter. There are a number of cases that both parties have cited, and the burden shifting framework is well established in North Carolina law. Under this framework, real property tax appeals start with the presumption that the county's assessment is correct. Now, to rebut this presumption, the taxpayer must produce competent, material, and substantial evidence tending to show that the assessor used either an arbitrary or an illegal method of assessment, and that the assessment substantially exceeds the true value of the subject property. Now, the taxpayer's burden is one of production, not one of persuasion. If the taxpayer meets this burden, the burden then shifts to the county, who must show that their methods produce the true value of the subject property. Chief Judge Stroud, the Property Tax Commission listened to Your Honor's instructions in the IBM case and properly applied the burden shifting framework here. Moreover, it properly documented exactly how it weighed the evidence and how it applied the burden shifting framework in its final decision. First, the Property Tax Commission correctly found that Unify produced competent, material, and substantial evidence to rebut the presumption of correctness. And Unify did this in several ways. Unify produced testimony and reports from 3 different expert witnesses, as well as testimony from the county's own consultant in order to rebut the presumption. Now, the first expert witness, and the one most relied on in the commission's final order, was Unify's expert appraisal, Scott Smith. And Smith was the only MAI certified and licensed North Carolina appraiser that testified in this matter. And Smith's appraisal report was the only uniform standards of professional appraisal practice compliant appraisal submitted in this matter. Smith used all three approaches to value to reach his final opinion, and he reconciled his values, placing the most weight on the sales comparison approach in order to reach a final value of $16,060,000, or $11,390,241 below the county's assessment that was under appeal. A significant factor in Smith's valuation was obsolescence, and a major source of obsolescence was that F1 tower. Smith conducted market research and determined that a prospective purchaser of T5 would not assign any value to floors 2 through 6 of the F1 tower. So in doing his assessment and his appraisal, he made adjustments in each of his three methodologies to account for this obsolescence. For example, in his sales comparison and income approaches, he reduced the usable square footage by removing floors 2 through 6 of the tower from the square footages, and then applied his calculations based on that reduced amount. Smith also opined that the assessor's cost approach here failed to account for this significant form of obsolescence. Now, this court has routinely held that evidence from an expert appraiser alone tending to show that the county's values substantially exceed the true value is sufficient to rebut the presumption of correctness. And we cite the Corning case for this proposition, among others, but the Corning case is extremely relevant to this case for a number of reasons. Corning also involved a manufacturing plant with an obsolete multi-story section. And like Smith did in this case, the appraiser, the taxpayer's appraiser in Corning, made certain reductions to account for obsolescence attributable to floors, the extra floors in that multi-story section. Just like Smith, he reduced his usable square footage by eliminating those extra stories based on his determination that a purchaser in the market would not assign value to those extra floors. The commission found, and this court affirmed, that the evidence from the taxpayer's appraiser was sufficient to rebut the presumption of correctness. Here, Smith used very similar appraisal methods, as did the appraiser in the Corning case, and his testimony on its own was sufficient to rebut the presumption of correctness. Nevertheless, Unify presented evidence from 2 additional expert witnesses that supported Smith's value conclusions. Unify presented evidence from Sohan Mangaldis, a global textile markets expert. To say that Mangaldis is an industry leader in data and statistics for the domestic and global textile markets is an understatement. He produced voluminous documents going through all the reasons why the domestic textile market, and in particular, the synthetic yarn market, the polyester market, was in substantial decline as production shifts overseas. And based on this testimony, he concluded that there was not a market participant that would be interested in purchasing Unify or T5 and specifically the F1 tower for its continued manufacturing use.
Mr. Marsh?
In addition to...
Sorry.
Yes, Your Honor.
Jump in there and ask you a question about that testimony. And Mr. Fisher has argued that the tax commission merely recited this testimony, didn't integrate it into its own findings, and also argued about some other evidence. But before we get to that, would you, if this panel agreed with Mr. Fisher that the commission's findings regarding this expert testimony were insufficient, is that so material that it would require reversal of the decision?
Your Honor, I do not believe it would be material sufficient to warrant reversal. And the reason being that ultimately the part of the evidence that the commission's final decision hinged on was the fact that it found that the sales comparison approach was the best evidence of value. And there was only one sales comparison approach offered. The county did not do one. And the Unify presented the only sales comparison approach prepared by a licensed North Carolina appraiser, that he applied adjustments pursuant to USPAP standards, whereas the county had no sales comparison approach, and it did not have a licensed appraiser to talk about a sales comparison approach. So I think that although this was a substantial evidentiary issue at the hearing, it was not the dispositive issue that changed the outcome in the commission's decision when it weighed the evidence. Moreover, you have to look back at the burden shifting framework and look at it from the perspective that Unify's obligation was to produce competent material and substantial evidence, which it did. And then the burden shifts to the county or the assessor to rebut that presumption, which it did not. And the commission was within its authority to weigh that evidence. Just getting ahead a little bit, but to respond to one of the factual challenges, finding of fact challenges that the appellant raises in this case related to the county's substantial evidence about the global textile market. The record on this is very clear that the articles that the county used in the hearing were totally irrelevant to the T5 plant and to its value and to the market in which T5 operates. They cite an article related to the expansion of the Reprieve product, and Mr. Bengaldis quickly testified that that expansion was taking place in Asia, not in Yadkinville, that the Yadkinville plant was continuing to shrink, and although portions of Reprieve, its slice of the pie, were growing slightly, the whole pie was shrinking and production out of the site was shrinking. Now, the other article they cite about the growth in the textile industry, Mr. Bengaldis also quickly pointed out that that's a totally different industry. That was an article about specific products. I think there are things like diapers and other materials, and the growth of that industry in other areas, not what's being produced at T5, not the materials. And so his evidence and his testimony remained strong that there was no participant in the market that would use T5 for its current operations, and especially that F1 tower, which is specific to these operations. Now, in addition to Mr. Bengaldis' testimony, which was truly uncontradicted, Unify also called Douglas Ferris as an expert in industrial real estate brokerage. And Mr. Ferris has sold just about every industrial property in the region. And his testimony was very thorough, talked about all of the issues that a seller, that Unify would face if it tried to sell the T5. And he was familiar with every single property that the parties cited in their various documents, in Smith's sales comparison approach, in the materials prepared by the county. And he was very direct on the point that there was a limited market for T5, that a potential buyer would assign no value to the F1 tower if it purchased the property, and that T5 would sell at or even below the $16,060,000 value from Smith's appraisal. In addition to Unify's own expert witnesses, Unify also called the assessor's consultant McCarthy, and McCarthy's own testimony rebutted the presumption of correctness that's afforded to his own assessment. McCarthy testified that his assessment relied entirely on the cost approach, that he did not consider functional obsolescence of T5, that the adjustments he did make to his assessment of T5 weren't based on data. They were based merely on his own judgment. And then his testimony also revealed that he ignored the true value standard applicable to property tax assessments. He testified that he had no opinion on whether there was a buyer for T5. He didn't do any market research. He didn't know whether there was a large or small buyer pool for T5, and he didn't know whether there's any market demand for F1. So he chipped holes in his own assessment. Based on the testimony and reports of these four expert witnesses, the Property Tax Commission correctly concluded that Unify rebutted the presumption of correctness. Now, before turning to the second phase of the burden shifting framework, which is how this court routinely looks at these appeals, I do want to address the county's arguments related to findings of fact and related to the first phase of the burden shifting framework, whether Unify rebutted the presumption of correctness. First, the county's brief and the county's oral argument never addressed whether Unify produced competent material and substantial evidence to rebut the presumption of correctness. It's clear that Unify did, but in any case, They didn't actually put any argument forth on this point, and I think have conceded it. Then the county asserts its miscellaneous challenges to findings of fact, and all of those challenges fail for any number of reasons. But the first reason that they fail across the board is that the county's challenges to the findings of fact ask this court to exceed its authority. They asked this court to replace the commission's role and weigh the evidence of the parties. That is the authority of the commission to listen to conflicting testimony, draw conclusions about credibility of witnesses, weigh the evidence, and reach final conclusions. And these challenges to the findings of fact all ask the court to substitute its own judgment for the commission by reweighing the findings of fact.
If I could just ask you on that last point, if this panel were persuaded by Mr. Fisher's argument concerning the findings of fact, and it were simply a matter of the appellate court staying within its lane and not invading the province of the commission, if there were an insufficiency, wouldn't that be a remand to the commission?
If there was an insufficiency, that would be remand, but there is no insufficiency here. The commission's role in making findings of fact and conclusions of law is very specific and perhaps unique from other circumstances, where the commission is supposed to describe exactly what evidence it considered and then weigh that evidence and then reach conclusions of law. So when we hear about challenges to the recitation of testimony, well, the commission is serving its role of describing the evidence that it considered and the evidence of both parties. Then the commission, and we've set forth in our brief the specific findings of fact that address each of the commission's functions, but I believe it's in the neighborhood of 1 through 12 address the evidence that the commission weighed, and 12 through 16 or 12 through 18 explain how the commission weighed that evidence and reached final conclusions. So the commission did exactly what it was supposed to do. If I understand the appellant's arguments correctly, some of them ask for the commission to make specific findings about specific pieces of evidence. Now, Judge Inman, I don't know that we cited a specific case on the question that you raised as to whether there's a presumption that evidence was considered, but we did cite case law to the effect that the commission's only required to make findings related to material facts. And here the commission made findings related to the material facts to reach its conclusions. And I do recall from other contexts that I've addressed at the appellate court, particularly GAL appeals and things of that nature, where the judge in those cases is not required to make a finding of fact based on every piece of evidence that's weighed. It is presumed that if the evidence is in the record that the judge considered it. Here, the evidence is in the record and the court can make the presumption that it was considered by the commission. Now, addressing some of these specific challenges to findings of fact, I think that these are all relatively straightforward and all without merit. First, the failure to make findings related to the values asserted by Unify at the board level. One, and I believe this language comes from the IBM case, the county can't swap horses now and assert a different argument that it did at the commission level. There is testimony about the values that were at various levels, but there was no argument whatsoever by the county's council, whether in closing or motions to dismiss, that addressed this point at all. It was not an issue that was brought up by the appellant, by the county at the commission hearing. Moreover, this challenge asks the court, this court, to reweigh the evidence. Again, the commission is supposed to look to see whether the taxpayer produces competent material and substantial evidence to support its value. Well, the competent material and substantial evidence that the commission found most persuasive supported a value of $16,060,000. That was the only evidence, and that was the only value that was supported by testimony from a licensed North Carolina appraiser, a MAI certified appraiser, and was reflected in a USPAP compliant appraisal report. To require a taxpayer to get the value right from the beginning before an appraiser is involved essentially places a burden on a taxpayer, whether a small homeowner or an industrial property owner, to get an appraisal on day one. at the local board level, because if you don't, you can never go back. You can never get an appraiser that tells you the right value. Again, Unify's burden is at the commission hearing to produce that evidence. And the commission has a de novo review over the appeal from the board level to the commission level. And that's when, in practice, folks hire appraisers to support their final opinion of value. I addressed the findings related to recitation of testimony. The commission is allowed to recite testimony as long as it makes findings of fact related to the material facts. Here, the commission was doing exactly what it was supposed to by identifying the evidence that was presented, weighing that evidence as set forth in its findings of fact, and then making final conclusions of law. The county also raised a point, and I don't think I heard it in an argument, but there is a point about no findings related to the schedule of values. And the county's own case, said in their brief, the Blue Ridge Mall case, is dispositive of that issue. Whether a county followed its schedule of values is not going to carry the day no matter what. It's a matter of weighing the evidence, whatever the commission determines is the most competent and substantial evidence to support its final decision. It's within the commission's authority to weigh that. Again, here, the commission had conflicting evidence, it weighed it, and it placed the greatest weight on Unify's evidence. Finally, on findings that don't address the sales comparison approach and the county's evidence, again, this is asking the court to reweigh the evidence. There is a ton of testimony from numerous witnesses about sales of different properties. What the commission did is identify which evidence out of that it found the most persuasive after weighing all of the evidence and made an appropriate finding of fact to record that. The commission is not required to address every single piece of evidence, which would be a never-ending burden on the commission, and it did exactly what's required by the law. Now, turning to the second phase of the burden shifting framework, the Property Tax Commission correctly concluded that the assessor failed to show that its methods produce the true value of T5. Recall that if the taxpayer meets its burden of production, there's now a burden of persuasion on the county to show that its methods produce true value. And the assessor's case here can be characterized as a complete failure of evidence. Rather than produce new evidence tending to show that its methods produce T5's true value, the assessor doubled down on its original flawed cost approach. The assessor did not present testimony from a licensed North Carolina appraiser, did not present testimony from an MAI certified appraiser, did not submit a USPAP compliant appraisal report. The county's only witnesses were its assessor, who testified that he was not involved in the valuation of T5, and then McCarthy, neither of which were licensed North Carolina appraisers. And then the county's only appraisal that it submitted was the original property record card that McCarthy prepared as part of the original assessment, the same assessment that was already reduced once by the county's own Board of Equalization and Review. And as I've already mentioned, the assessment was based entirely on a flawed cost approach with arbitrary adjustments, and it didn't account for the true value standard at all. And this court has routinely criticized the cost approach. We cite the Lowe's case, among others, to this point, that the cost approach is the least reliable method to assess property, and it should be used to establish a ceiling on value rather than the true value. Nevertheless, the assessor failed to marshal any evidence beyond its flawed cost approach. And the assessor's failure of evidence is in stark contrast to the substantial evidence produced by Unify through multiple expert witnesses and through cross-examination of the county's own witnesses. The Property Tax Commission properly weighed the party's evidence and correctly concluded that the assessor failed to meet its burden to show that its methods produce the true value of T5. Your Honors, this is not a close case. The Property Tax Commission correctly found that the assessor used an illegal appraisal method, a flawed cost approach, and that the assessment substantially exceeded the true value of T5 by more than $11 million. And finally, that the true value of T5 was the true value based on the competent material and substantial evidence produced by Unify's witnesses of $16,060,000. Therefore, we respectfully request that this court affirm the Property Tax Commission's decision.
All right, thank you. Any questions?
Just one very brief question. The testimony by Mr. Mongaldas was about, I came away with the understanding of it being about market obsolescence. Is there a difference between market obsolescence and functional obsolescence?
Yeah, so his testimony did primarily focus on economic obsolescence. And by that, he testified that the economy and the textile industry had changed drastically since Unify's T5 plant was constructed. And perhaps at the time the T5 plant was constructed, there may have been market participants that would be interested in purchasing the T5 plant for its continued manufacturing use of synthetic yarn, and specifically the F1 tower. Now, over time, the industry has changed, and as Mongaldas testified, his report shows, production has gone overseas, and the domestic production is a small fraction. So there's no demand now in the market for the facility, and especially the F1 tower.
Okay, and I guess the functional obsolescence has to do with the shape of that tower,
yeah,
rather than that industry.
Yes, Your Honor. There's a bit of overlap with functional economic obsolescence here, where there is some functional obsolescence. There's other functional obsolescence that was included in Smith's report that also warranted reductions, and that was some dated equipment, some dated airing systems, and some spaces under the floor. So both were present in this case.
Thanks.
Thank you, Your Honor.
All right.
Thank you.
All right. Fisher, I'll give you your full 5 minutes of rebuttal.
Thank you very much.
Part of your 5.
Thank you. Just a couple of points. I might not even need the whole 5 minutes. I think it interesting that Mr. Marsh told the court that, if I may paraphrase, that Mr. Mongaldas was pretty much the expert when it comes to global economic markets, with the training he's had and the statistics that he has offered and the charts that he presented and all of that. That very well may be true. And certainly, kind of going back to Judge Inman's question, the issue of economic obsolescence is integrally related to the overall economic market for a plant such as this. That being the case, again, it was up to the commission to do more than merely say he testified about that. And if you read that order, nowhere, or the decision, excuse me, nowhere in there is there any integration into a specific finding. He testified, that was it. The language read similarly about the various appraisers, but the commission did integrate that, not as to Mr. Mongaldas, which of course is, again, inconsistent with the company's own press release that we've previously discussed. This is a situation that's likely to recur, because the whole issue of abandoned plants is probably going to go forward as we have this economic upheaval, current pandemic. Counties obviously have to rely upon property taxes for the vast majority of their revenue. And what this court can do by its decision is to provide clarity to counties about how things should go forward in doing their assessment and what value abandoned plants has for those companies and counties that follow the sales comparison approach. Mr. Smith testified that most of the listings he referenced in his report were plants that had been shut down and were vacant. As I said, one for 8 years, even though he wasn't aware of that fact. That being the case, a finding that says, well, that might be an issue. Might not be an issue, but it might be an issue, recognizes at least a potential problem, to quote the commission. And if you recognize that problem, you're going to rely upon this expert, then you've got to resolve that problem. That is the sort of clarity, I think, going forward that counties and taxpayers need. And that's what we would ask the court to do. So at a minimum, we contend that this matter requires remand based upon this issue and the other issues we've made as to the findings. And I thank you for your attention this morning.
All right. Well, thank you very much. And in fact, I'm sorry. I was going to ask Mr. Marsh also. Were you able to see the timer? I'm curious about that now, since we had that come up.
Your Honor, we were able to see the timer.
Okay, all right. Well, we'll have to figure that out. Like I said, I know I've had some attorneys say they have that problem and some don't, and that's a technical issue that's probably beyond my expertise. But our IT people can figure that out for us, so we'll check with them. But anyway, thank you very much for your arguments this morning. Good arguments. We appreciate that and give us some things to think about. So, all right, then we will adjourn.
This session of the North Carolina Court of Appeals is now adjourned.